welcome back to North of the Broad. Brent Stewart has joined us. He's the founding attorney for Stewart Law Offices. Today we're going to talk about slips and falls.
All right, let's do it.
And so you have to be on somebody else's property, and it has to be their fault. If it's negligence, there's something wrong.
It has to be on somebody's property, but almost every place is controlled by somebody. So the starting point with a slip and fall case is determine who is responsible for the area. One thing we get, or people often they'll call and they'll say, I fell, and I will say, what did you fall in? And they will say, I don't know. And then I explain to them, just because you fall doesn't mean you have a case. We have to know where you fell, why you fell, and then we have to show that the homeowner or landowner knew or should have known that area was an issue, and then they failed to remedy that issue. So just because you fall doesn't mean you have a case.
Okay, so Brent, I'm going to give you an example. You're in a store, and there is some fluid, water, whatever, on the floor, but there are some signs that say caution.
Right.
And I actually slip and I fall, kind of on the outskirts of that. Do I have a case?
I think if they have the signs up and they've marked the area, I think they've done what they need to do, and I personally want to bring a case. My fear is, or what I try not to do, is file a case where we get 2 years into it and then I have to tell the client, hey, you have no case. Nobody wants to go through 2 years of litigation for nothing. So part of being a good attorney is not only telling people they have cases,
but that they don't.
But realistically telling them what doesn't exist in a case. And people will get upset when it happens, but in the long run, I think you're doing the best for the client.
Okay, so let's say there weren't signs and I fell and I have a case. Let's walk through the process.
Well, just because there weren't signs doesn't mean you have a case.
Okay.
You have to show that water was there and they knew or should have known that the water was there, and then they either failed to remedy the situation or they chose just not to or waited too long to do it. And there are ways to tell with most stores, because they have procedures that say they have to do a walkthrough every hour to make sure if any danger is on the floor. So if you can show that they didn't do the walkthroughs, then they haven't satisfied their store policy, then they knew or should have known the water was there, and then you have a case. So there are a bunch of hoops to fall. You just can't fall and get a recovery.
Okay.
I get those calls all the time. You have to know why you fell, and then we have to find it to be a negligent situation. And a good personal injury lawyer doesn't want to just bring any case they can. They want to bring valid cases, because otherwise it just gives the whole occupation a bad name.
Right, very good. And so your attorneys become investigators, really. They begin, they figure out if there's a case.
The first thing we would do in a slip and fall case, or a lot of cases, is what's called a spoliation letter. And that's saying, hey, store, something happened in this area. Keep all documentation of what happened. Keep all the incident reports. If you have film, keep these films. And if you send that out and then they destroy some of the evidence, in the end, if you get to a trial, you can have a jury instruction that says, hey, it is presumed they destroyed this evidence after getting this letter, and they presumably did it to protect themselves. So you can use a negative inference off that jury instruction. So your personal injury lawyer should immediately jump on it, send out spoliation letters, send out notice letters, and get the evidence that might disappear.
So if we have a case, how many months, and you can't define exactly, but how long does it take?
So I get that question a lot, and I don't think any personal injury lawyer should settle a case until they know exactly what the client's injuries are going to be. So if somebody gets in a wreck and they're better in 4 weeks and they're totally better, then you can get that settled maybe in 6 months. But as long as the person is still treating and in active treatment, and the doctor can't give us an evaluation as to what medicals might be needed in the future, you're kind of doing a disservice by settling the case too quickly. That being said, clients want their money, they want it done. We work for them. That's the bottom line. We can give them advice. If they don't listen, then we have to do what they say within reason if it's not ethical, if it's ethical. But for the most, you shouldn't settle your case until you're at something I like to call maximum medical improvement. You're as good as you're going to get, and the doctor knows exactly what you're going to need in the future.
So you mentioned we work for them. So what is the culture of Stewart Law Offices? What is your heart?
Well, the bottom line is meeting people, and it's at a period when they're down on their luck and they're afraid they're not going to be able to work. And so we have to understand that they may be aggressive, they may be combative. There's things that are happening that it's just not a good time for them. So we need to offer sympathy and listen. And that's why I like face-to-face meetings now. But I think we have to offer sympathy and take calls. The most important thing is take people's calls and listen. Listening is the most important thing.
Listening is critical, and you're right. It's at a very emotional time for folks. So thank you so much, Brent, for your service. And if you want more information about the Stewart Law Offices, you can
give us a call at 866-STUART. You can Alexa me, you can Siri me, you can Google me at 866-STUART or Stewart Law Offices, and ask for me. My name is Brent. I'll be glad to talk to you personally.
Great information. Thank you so much. Brent Stewart with Stewart Law Offices, and we'll be right back with more North of the Broad. Don't go away.